When an acquiring company uses securities as consideration in an M&A transaction, those securities must either be registered with the Securities and Exchange Commission or qualify for an exemption from registration. In another lesson, we discussed how complex and time-consuming the securities registration process can be. Fortunately, several exemptions allow companies to offer and sell securities without registration. In this lesson, we'll explore some of the exemptions commonly used in M&A transactions. Section 4A2 of the Securities Act exempts from registration transactions not involving any public offering. To qualify for this so-called private placement exemption, the purchasers of the securities must 1. Either be sophisticated investors or have access to the type of information normally provided in a registration statement, and 2. Agree not to resell or distribute the securities to the public. Because it's often difficult to determine whether these subjective requirements have been satisfied, the SEC has adopted several objective safe harbor provisions. In the context of M&A, the most frequently used registration exemption is found in one of these safe harbor provisions, Rule 506 of Regulation D. As a Section 4A2 safe harbor, Rule 506 only exempts from registration transactions by an issuer not involving any public offering. Thus, Rule 506 only applies to public companies acquiring private targets. If the target company is public, there is no exemption, and all securities issued to the company and its shareholders must be registered.